Good afternoon, and thank you for joining us for our presentation on the difference between employees and independent contractors. This presentation is intended to help business owners understand that important distinction and why properly characterizing a worker as either an employee or an independent contractor is essential for any business. I'm Mary Kogut-Lowell, staff attorney for the Community Economic Development Unit at Legal Aid Service of Broward and Collier counties. Our unit works with small businesses and with nonprofit organizations who are providing vital community services to low and moderate income individuals. We have a variety of programs to assist small businesses, but in Collier County, we are especially proud of our new Small Business Legal Resources Project for eligible small businesses, which were impacted by the COVID-19 pandemic and which require legal and/or accounting services to enable job creation or retention for low-income employees. The SBLR project is funded in part by a community development block grant by the U.S. Department of Housing and Urban Development, facilitated through Collier County's Human and Community Services Division. The goal under the grant is low to moderate income creation. Now, this presentation was pre-recorded by Callie Soldavini, the SBLR project attorney who is out today on leave. So I'm here to answer any questions that may come in through the chat function on Zoom or the comments on Facebook. But first, a disclaimer. This presentation and its contents are intended to convey general information only and not to provide legal advice or opinions. The applicable Florida law is complicated and fact-specific. Nothing in this presentation is intended to establish an attorney-client relationship with Legal Aid of Broward and Collier counties. You should consult with or retain a qualified attorney if you have specific legal issues. At the end of this presentation, we will have contact information for the SBLR project so that you can apply for services through our program if your small business needs legal assistance. Now, if you have any questions today, you can put them in the chat box if you're on Zoom or in the comments if you're on Facebook. We will get to as many questions as possible at the end of the presentation. On that note, we will start the presentation.
Hi, my name is Callie Soldavini, and I'm a staff attorney at Legal Aid Service of Collier County, a subdivision of Legal Aid Service of Broward County, working in our Community Economic Development Unit. And we serve two types of clients. One is small businesses, and two is nonprofits. And today we are presenting on a really important concept for both types of organizations: the differences between employees versus independent contractors. And the contents of today's presentation will be to discuss the free legal services for qualifying small businesses and nonprofits at Legal Aid. 2, the differences between the classifications for independent contractors and employees. 3, consequences of incorrect classification of an employer or employee, which is very common. And 4, federal versus state interpretation of independent contractors versus employees. A quick disclaimer that everything we talk about in today's presentation is intended to convey general information as it applies to general situations. So if you need to follow any advice in this presentation, please consult with or retain a qualified attorney on all matters as they relate to your specific situation. And hopefully you may qualify for our free legal services. Our presentation, as well as our program at Legal Aid, is funded by the Florida Bar Foundation through our statewide Florida Community Development Legal Project, as well as a Community Development Block Grant, a CARES Act grant, funded by HUD and facilitated through Collier County's Human and Community Division Services. Now, talking about the free legal services, we have 3 tracks of clients that are eligible to receive free legal representation from Legal Aid's Community Economic Development Unit. And when I say free representation, it is as if you're walking into a law firm and you would have an attorney-client relationship and be able to receive certain eligible free services for your small business or nonprofit. The first tract of clients are businesses owned by low to moderate income owners. So this is a statewide business, a small business owned by low to moderate income individuals. And that is defined as up to 140% of the county's average median income, and that's determined by HUD. A second tract of clients is businesses creating or retaining low income jobs. So Collier County businesses are the only businesses that qualify under this grant, as well as nonprofits that create or retain low-income jobs. And that is defined as up to 50% of Collier County's area median income. And this is despite being harmed by the pandemic, businesses were able to save jobs. And businesses have to have under $5 million in gross revenue. So under this tract of clients, it does not matter the business owner's income, only that job creation and retention is occurring after the pandemic. And finally, the third tract of clients is nonprofit organizations. Statewide nonprofits providing critical services to low-income communities, and then that nonprofit cannot afford an attorney. The services provided are, such examples are entity selection and advice and counsel for limiting liability, organizational documents and filings with the state, such as the articles of incorporation or organization and any amendments to those documents, business governing agreements. And if you are interested in learning more about business governing agreements, referred to as bylaws, operating agreements, or partnership agreements, we do have a presentation on that as well. And you can find that on Legal Aid Service of Collier County's YouTube channel. Succession planning for your business, reviewing agreements that your business already has in place to make sure that they're still in compliance with best practices and current laws, fictitious name, advice and registration, instructions on filing annual reports and other required state filings, as well as county required filings. Contract drafting, review, and negotiation is the bulk of our unit's work. Template agreement for customer services, commercial lease drafting, review, negotiation, or renegotiation, non-disclosures, non-competes, confidentiality agreements, legal governance training, if you just have some general legal questions about how your organization needs to operate to comply with Florida statute and other laws, business acquisition representation, real estate and financial closings, dispute resolutions. We also refer our clients to local free or very low cost business consulting services and much more. We try to act as free corporate counsel or in-house counsel to our clients and address any legal needs as they arise. Getting to the content of our presentation, we're going to be looking at the difference again between independent contractors and employees and the little consequences that come with an improper classification. And this is a very complicated topic because there is no clear definition of what an independent contractor is versus an employee. And there is a slew of both federal and state laws that define it differently. So we're going to be looking at all the ways it's being defined and all of the ways that it can create a risk for your business when it's misclassified. And classifying hires as an employee or an independent contractor has various impacts on the wages that are paid from the employer to the employee, taxes and withholdings, fringe benefits, the behavior and relationship between the employer and employee, schedules, record keeping. And both employees and independent contractors have different benefits and disadvantages to your business. Oftentimes, as I describe all of the things that an employer would not have to do if they had just hired an independent contractor versus an employee, you may think, wow, this is great. I should just hire independent contractors. But as you'll see, the law tends to look at a certain position or how you're treating someone that you hire as an employee, it may not be worth the risk to identify them as an independent contractor versus an employee. There are certainly more steps involved for employers hiring employees, but they're all manageable, and we hope to go through some of those, at least at the surface level today. And then again, please consult with an attorney for your specific situation. What is an independent contractor? What is the definition? Sometimes it's referred to as a freelancer, and an independent contractor operates under their own registered business name. So if you hire someone, that person is, or business is operating under their own name. Unless they're a sole proprietor, then the sole proprietor is operating under their actual individual name. And that business, independent contractor, may have their own employees. They may advertise. They do maintain a separate business account, a separate bank account, and send invoices on behalf of their business. They typically have, but don't have to have, more than one client. They own tools. They own their own tools. They're not using the tools of their employer. They have the flexibility to set their own hours, and they keep their own business records. So again, there is no clear definition, but over time, how courts analyze what independent contractors are, these are some of the common threads that we see. But as I said, this is a complicated topic, and there's often a lot of overlap between the definition for independent contractors versus employees. But generally speaking, employees get paid for work while under the direct supervision of an employer. On the other hand, independent contractors take on a job for a price. The independent contractor will decide the work to be done and decide if it's necessary to hire others to help with the work. And a little practice tip here is that Florida is what's called an at-will employment state. And that means that any employee can be terminated or voluntarily leave at any time during the employment without further liability to either party, absent an agreement otherwise, of course. So this provides a lot of flexibility for your business. So you want to be careful. A lot of times businesses think, oh, I'm hiring someone, I have to have a written agreement. That really depends on the situation of your business, and it certainly will depend on whether the hire is going to be considered an employee or an independent contractor. Because we're an at-will employment state here in Florida, you don't want to limit that flexibility by drafting restrictive employment contracts, which are not required by Florida law. You don't have to have an employment contract unless you desire to define or change that at-will relationship, and you do want some kind of formal notices before an employee can leave your employment. And with independent contractors, we always recommend to our clients, absent really stringent circumstances, that an independent contractor agreement, a written agreement defining the relationship, be in place. When hiring an independent contractor, the business should have a written agreement outlining what's the work to be completed, what are the payment terms, who has liability for what, and remedies if the independent contractor performs that work unsatisfactory. As mentioned, employees are defined in both federal and state law, but not clearly. Federal law has not created any clear guidance. Really, we're just pulling, a lot of this presentation is pulling a lot of piecemeal definitions by different federal agencies and some state agencies, and pulling together kind of a consistent definition. But again, it's really not clear. So just like when you pay your taxes, even though there's no black and white formula and clear answer to what's due, what's owed, employers are still responsible to get it right or pay the consequences. So it's really important that you lean on the side of caution when you identify an independent contractor as an independent contractor, an employee as an employee, because you will be held responsible for the consequences of misclassification, even if you argue there's no clear definition or you didn't understand the law. Let's look at a few differences between what we looked at in independent contractors with employees. And three main differences we'll talk about are taxes, Social Security and unemployment insurance, and healthcare and retirement benefits. And taxes are a big issue. Employers don't want to have to pay and be responsible for taxes. Employers are responsible to withhold employees' federal and state income taxes and pay the withheld taxes to the IRS and applicable state agencies. But for independent contractors, that's not the case. So this is one of those reasons I say it might look really favorable to identify a hire as an independent contractor, because then the business isn't dealing with those pesky withholdings and the things you have to do as a result of that. For example, when an employee is hired, the business provides a W-4 for the employee to complete and return. And by January 31st of the following year, the business has to provide the employee with W-2s summarizing the employee's wages and withholdings for the previous year. But with an independent contractor, the independent contractor pays their own taxes. Employers generally don't need to worry about withholdings. However, IRS can penalize employees for misclassification. So again, you want to make sure that you have it right. And one way we'll do that is by taking a deeper look at the definition of an employee versus what we already defined, the independent contractor, in the upcoming slides. A second difference is Social Security and unemployment insurance. Employers are generally required to make payments to Social Security and unemployment insurance for their employees, while independent contractors make their own. So employers don't need to worry about purchasing unemployment insurance for independent contractors, because as we looked at the definition of an independent contractor is viewed as self-employed, not as an employee of the employer. And third, another difference is healthcare and retirement benefits, or other fringe benefits. Employees' benefits generally fall in two categories. One is those that are required by law, and two is those that an employer chooses to offer voluntarily to be able to retain the best and most qualified employees. And employers are required by law to offer to employees fringe benefits to compete in the marketplace. They must make those available to all employees. Employees entitled to fringe benefits, so these could be sick leave, vacation, paid time off, healthcare. Under federal laws and regulations, employees are entitled to them, but not independent contractors. So what are required fringe benefits? Again, you'll need to consult with an attorney on your specific situation and how state law will apply, but the 5 general required fringe benefits are Medicare and Social Security contributions. These are federally mandated benefits that employees pay the U.S. and then in case they need it later in life for retirement and health insurance, for their retirement or for health insurance when they're 65 or older, or with certain medical conditions. Second is workers' compensation insurance, which covers the cost of medical treatment, rehabilitation, paid leave, or replacement income for employees who have an injury or an illness related to their job. 3 is unemployment insurance, and it's the partial income replacement for a short time for employees that are involuntarily out of the job. 4 is health insurance, and this is currently regulated by the Affordable Care Act, and it requires any organization that employs 50 or more full-time employees to provide health care coverage. And then finally, the Family and Medical Leave Act. Again, if there's 50 or more employees, this act requires employers to provide its workers with up to 12 weeks unpaid leave while still protecting their job security for certain family, personal, and medical needs. What are the harms caused by misclassification? One, your employer may be required, you as the employer may be required to reimburse employee benefits under the Fair Labor Standards Act. So that can be overtime and minimum wage. Two, the employer will have to pay back taxes and penalties for federal and state withholdings. Three, the employer may have to pay Social Security and Medicare payments that should have been made to an employee. Four, the employer may have to provide employees with benefits that it was required to, if it was required to, such as health insurance and retirement benefits. Five, penalties if the governing authority determines the misclassification was on purpose. If it was to make life easier, if it was to avoid having to pay taxes or give the employee certain rights. And there are plenty of law firms that will aggressively represent clients that are employees and pursue employers for misclassification and make the argument that it was on purpose. Six, employers can be held liable for their employees' negligence if they're acting in the scope of the employment. So it really will matter if an independent contractor versus an employee hurts someone or themselves or causes damage, such as property damage in the course of the employment. And seven, employers have a duty to maintain a reasonable, safe work environment. So they'll need sufficient insurance like workers' compensation and general liability insurance. And while these are still important to consider for independent contractors, it's far more important for employers to consider it. So these are some of the harms caused by incorrect classification. So again, our advice as attorneys is always to err on the side of caution. Generally, an employer cannot be held liable for the negligence of independent contractors. Of course, certain exceptions apply, but that's another consideration. So it's really important to have that sufficient insurance mentioned, liability and indemnity provisions in contracts with independent contractors to ensure that the business is properly protected. And this is an area where we really recommend having an attorney draft and take a look at an independent contractor agreement that you utilize. And hopefully some of the businesses here qualify for our services, and we would be able to draft that or review what you have. A frequently asked question I get all the time is, what if I have the individual or business that I hire sign a contract stating that they're an independent contractor, and I get them to agree in writing that they will be classified as an independent contractor and not an employer? Employees do not become independent contractors under really any law or any interpretation just simply by signing an agreement stating that they are. A written agreement stating someone is an independent contractor may not be enough. It's still helpful. It still makes for a helpful argument, but that in and of itself is not going to make the determination that the classification will stand. An independent contractor actually has to walk and talk like an independent contractor. Going back to that independent contractor definition, those factors, and not act like an employee. So what we're going to do next is analyze what courts look at and what administrative agencies look at when they're trying to determine what an employee is and what they'll consider if they do have a reason to need to consider if there was a misclassification as an employee or independent contractor. And as we run through these examples, I recommend having a situation in mind or potentially a hire that your business has made in mind, and kind of use that as an example as we go through what the definition of an independent contractor is, or an employer is. So looking at the different federal agencies that define employees versus independent contractors differently, they all have a different definition that suits their own purpose. Under the Small Business Administration, this is a federal agency that did a lot of the pandemic relief funds. It defines an employee as a hire that generally, one, performs duties dictated or controlled by the employer. Two, is given training for work to be done. And three, works for one employer. Moving over to a different federal agency, or legislation, the National Labor Relations Act defines employees as anyone not excluded. So anyone that's not listed here. Agricultural laborers, household employees in domestic service at home, parental employment, and independent contractors. So that definition is saying anyone with these four are are employees. So that's a really, really broad definition. And the IRS is what we're going to focus on the next couple of slides. The IRS defines an employee as if the payer has the right to control. And this is a really determinative factor, the right to control or direct not only the results of the work, but how it will be done. So let's take a look at this right to control or direct only the results of the work and not what will be done and how it will be done. Evidence indicating the degree of control over workers falls into three main categories: behavioral control, financial control, and the type of relationship between the parties. So the IRS is going to look at behavioral controls. When does the hire work? Where do they work? What equipment do they use? Whether the worker is provided training or how to do the job, whether the worker is evaluated based on the result of the work or based on how they perform each step of the work. Financial controls IRS will look at are whether the worker earns a salary, hourly rate, wage, or is paid upon completion of the work. Whether the worker is reimbursed for expenses or if the employer covers costs. And who pays for or owns tools and equipment. Finally, the relationship of the parties. The IRS will look at contracts to see how the relationship is defined, what benefits are, the permanency of the relationship, and regular business activities. So it's really kind of done on a case-by-case basis. There is no clear way to determine what the right to control is, but really looking at each specific situation. And while certain factors suggest the existence of control, none of the factors mentioned is determinative. Even if the employer has legal rights to impose control but chooses not to, if the employer has the right to but chooses not to, it can still be classified as an employee rather than an independent contractor. In addition to the federal tax code, there are dozens of other federal employment laws that exist. However, determinations made under those other federal laws regarding worker classification are not binding on the IRS. So when the IRS is going to look out for wanting to snag from your business those taxes and withholdings that are due, and potentially misclassification of an independent contractor versus an employee, it's going to look to this IRS right to control standard and make the argument that the business does owe these taxes and that there was a certain threshold of a right to control, even if the employer didn't exercise that right, just having the right will be enough. So the takeaway is that it's really important to properly categorize workers because of tax and liability implications. And while your business may be tempted to categorize every worker as an independent contractor because of the significant tax savings, the IRS penalties for incorrectly categorizing a worker, especially if on purpose, can be severe. So you want to consult with your tax and legal professionals on the best route to take. So let's apply what we discussed to an example to sort of bring this different definition between an employee and independent contractor to life. We'll look at two examples between Maria and Preet. Maria is starting an e-commerce business called Plants. She wants to hire workers to fulfill orders, and the workers will be required to attend an orientation at Plants headquarters prior to their first day of work, where Maria will teach them how to package and ship orders. The workers will work from 9 to 5, Monday through Friday at the Plants headquarters. They'll be paid an hourly wage of $15 an hour and are provided the appropriate gear and equipment. On the other hand, Preet is starting a music blog and wants to hire workers to write articles. Each worker can submit up to 10 articles per month and will be paid $100 for each article submitted. The workers can choose any genre, band, or musician to write about. They can work from home at Starbucks on their laptops, and they can create their own schedules. So analyzing these two situations, the first one with Maria would likely be classified as an employee, while Preet's an independent contractor. So why? Maria exercises a significant amount of control over her workers. But what she does is she provides instructions tells them how to do their job, when and where they work, and pays wages based on that hourly work. Preet exercises little control. Preet, on the other hand, exercises little control. The writers make their own schedules. They're paid upon completion of the task. They're not being told how to write, what to write about, and they use their own equipment. So these are two pretty good examples of how an employee would be defined and how an independent contractor would be defined. Some additional factors for independent contractors versus employment that are, again, kind of pulled from multiple administrations and statutes. Courts will look at the worker's class or level. So it's not dispositive, however, the more unspecialized the position is, the more likely that worker will be subject to the employer's direction and therefore be an employee. So if the employee doesn't really know what they're doing, you have to provide a lot of guidance and training, again, more likely an employee. But if they have their own specialty, if they know what they're doing, especially if it's a specialty that your business doesn't have, and you really turn over the work to them and they determine how to do that work, then it will be more likely that they are an independent contractor. 2, nature of the business. If the hired worker has a special skill or does work beyond the expertise or usual line of work of the employer, courts are more likely to view the worker as an independent contractor. 3, the power to discharge. At-will termination strongly indicates employee. 4, understanding of the parties. If the parties believe they have an employee or independent contractor relationship, just the belief will generally be entitled to some wage, as we mentioned, but not determinative. So really, courts are going to look at this if the other criteria are ambiguous, but won't be determinative. And finally, what's the custom in the industry? If the custom in the trade or industry is for the services to be provided by employees or independent contractors, courts will at least look at that customary status and see if one is indicated. What is Florida's interpretation? So we've looked at a lot of federal law, mostly focusing on IRS and the way IRS will determine the employee versus employer relationship. But what about in the state of Florida, since we're talking about Florida businesses in this presentation? Under Florida law, you guessed it, there is no established definition of independent contractor. So courts apply different tests to determine independent contractor or employee misclassification. So what does Florida look at? If there's no clear written statute, but courts have sort of made this list up over time and have determined here's what we're going to look at when we decide if an employer is misclassifying an employer independent contractor. So what does Florida look at? There's no clear written statute, but courts have sort of made this list up over time and have determined here's what we're going to look at when we decide if an employer is misclassifying an employer independent contractor. Out supervision in the relevant locality, the level of skill required for the job, whether the person supplies their own tools and place of work to do that job, how long the person is employed, whether the person is paid by the time spent or by the job completed, whether the work performed is in the employer's regular business, whether the parties believe they are creating an employer and employee relationship or independent contractor relationship, and finally, whether the employer is or is not in business. But that's what the courts will look at. Under Florida workers' compensation law, generally a person qualifies as an independent contractor if they satisfy at least 4 of the 6 listed criteria on the screen. 1, separate business with own work facility, equipment, and materials. 2, the hire has their own federal employment identification number, unless there is sole proprietorship. You're not required to have your own FEIN. 3, compensation paid to businesses rather than individuals. 4, there's 1 or more bank accounts in the name of the business for business expenses. 5, the hire can perform work for others at its own election, and the business that hires them doesn't try to restrict that for the most part, absent extenuating circumstances. And 6, the hire receives compensation on a competitive bid basis or completion of the tasks defined by a contractual agreement. So again, it's meeting 4 of these 6 criteria. Not all of them have to be met. Because independent contractors are not eligible to file workers' compensation claims under Florida law, employers are not required to obtain workers' compensation coverage for independent contractors. So businesses tend to want to misclassify or properly classify a hire as an independent contractor. But you want to be sure because of the consequences. The Florida Department of Financial Services administers and enforces these independent contractor classifications, and they may bring in action in circuit court to recover any assessed penalties against a business that misproperly classified. And misclassification evaluations are typically triggered, meaning that the FDFS will start litigation when an alleged independent contractor who claims to be an employee either files a claim for benefits or workers' compensation with the FDFS, or they file a claim in court under the workers' compensation law. And FDFS is aggressive when a complaint is filed, bringing the independent contractor classification issue to its attention. So if someone that your business hires claims to be an employee and claims to be entitled to Florida's workers' compensation, that is when the investigation will be triggered most typically. The Florida Whistleblower Act also discusses the misclassification but doesn't have a clear definition. And misclassification evaluations are typically triggered when an alleged independent contractor who claims to be an employee files a complaint with the Florida Inspector General or with the Florida Commission on Human Relations. Evaluations may also be triggered if the person files a claim in court under the Public Employer Whistleblowers Act. So if you do have someone that works for your business that is that does act as a whistleblower, that may trigger an investigation. And there's also the Florida Reemployment Assistance Program. This is often referred to as unemployment law, and again, no clear definition. And the misclassification evaluations of a business are triggered when an alleged independent contractor claims that they're an employee and files a claim with the Florida agency for workforce innovation for unemployment compensation. So this happened a lot during the pandemic and really triggered the difference between independent contractors and employees, because a lot of people that lost work were trying to make the argument that they were actually an employee entitled to certain benefits under the Florida Reemployment Assistance Program or unemployment law. So that will be triggered when someone that you hire claims that they're actually an employee entitled to unemployment compensation. And then the Florida Wage and Hours Law uses the federal law as the SLA's definition of an independent contractor. So again, you see that we're all over the map here. The only thing that's clear is that there is no clear and consistent definition. But we want to look at all of the ways that the agencies, federal and state, and statutes and federal laws define independent contractor versus employee. And it's best to just sum it up. And a good summary is the table that I have up on the screen. So it's pulling together everything we looked at in today's presentation and kind of puts the employee versus independent contractor determination side by side. So to review, the most important, the right to control, seems to be the most dispositive. If the employer controls the details of the work, more likely an employee. The worker controls the worker, as opposed to the employee controls the work of the details, more likely an independent contractor. You can look at the type of business. If the worker is not engaged in business or occupation distinct from employers, worker is probably an employee. If the worker operates in a business that is distinct, more likely an independent contractor. Looking at supervision, if the employer supervises the work and the nitty-gritty details of how it's done, where it's done, with what tools it's done with, more likely an employee. If work is done without supervision, more likely an independent contractor. Looking at skill level as a factor. The skill level need not be high or unique for an employee. But if the skill is specialized, it's unique, it's something that requires substantial training, and that training is provided by the independent contractor, not the employer, or perhaps it's a licensed job, more likely an independent contractor. Looking at tools and materials as a factor, if the employer provides the instrumentalities, tools, and location of the workplace, that's more likely an employee. But if the worker is employed for a specific project for a limited time, more likely an independent contractor. Another factor, continuing relationship. The relationship worker is employed for extended and continuous period. That's probably an employee. If the worker is employed for a specific project, or is paid by the project as opposed to computation based on the time that was worked, that's more likely an independent contractor. Sorry, let me backtrack. So tools, if the employer provides instrumentality, tools, and location, more likely an employee. If the tools are provided, if the worker provides them and the workplace, more likely an independent contractor. And then the relationship, the worker is employed for extended continuous period, that's probably an employee. But if it's just related to a specific job, then that is more likely an independent contractor. And then kind of tying into those, method of payment. If the worker is paid by the hour or other computation based on the time work is used to determine pay, that's more likely an employee. If the work is not part of the employer's regular business, that's probably an independent contractor. Integration as a factor. If the worker is part of the employee's regular business, that tends to be an employee. But if they're not part of the regular business, that tends to be an independent contractor. And then a factor, the intent of the parties. If the employer intends to create an employer-employee relationship, of course, more likely an employee. But if they don't intend to, more likely an independent contractor. And the final factor that seems to be consistent through federal and state law is employment by more than one place. If the worker provides services to one employer, that leans towards an employee relationship. But if the employment it has multiple businesses that it serves, that hire is likely an independent contractor. So we're all over the place here, but you want to take a look at these factors, make a determination, and err on the side of safety, because you don't want to be in the position where your business is being threatened by an administrative agency, whether federal or state, or by someone that says that they're an employee, even though you thought they were an independent contractor. Instead, you want to make sure your business is safe and protected and has thoroughly looked at all of the factors and considerations, and didn't just make the determination based on ease, based on saving taxes or not having to deal with certain laws and pay. I hope that this presentation was helpful, especially for our small businesses that are struggling to identify hires as independent contractors or employees, and make some of this really complicated and really overlapping laws and regulations a little bit clearer. If you believe that you may qualify for our services, I hope that you reach out to me or the paralegal in our unit, Mrs. Sherry Despointes, and our 2 emails are up on the screen. And I'm also happy to answer questions as they relate to the presentation. I've also listed 3 websites, the Collier Legal Aid website, Broward's Legal Aid website, and our statewide legal website. Because again, small businesses statewide, as well as specifically to Collier County, qualify for our free legal services. Thank you so much for tuning in, and we're here to help.
Okay, let's see. After that presentation, I don't see any questions in the chat box, but I do have a couple of thoughts that we can talk over just to summarize. First of all, what's the bottom line here? What's the difference between an employee and an independent contractor? That's the big question. Well, as you've seen from the presentation, there are many differences between independent contractors and employees. But the most important and obvious factor is whether the employer or the payer has the right to control or direct the means or method of accomplishing the work. In other words, the right to control is critical when determining whether an individual is an independent contractor or employee. And as discussed in the presentation, many factors go into considering that, but the big question is the right to control and whether the payer has the right to control. And we can look at it from the perspective as defined by the IRS. A person is an independent contractor, quote, if the payer has the right to control or direct only the results of the work and not what will be done and how it will be done. So that's pretty much the bottom line in terms of what's the big difference between an employee and an independent contractor. Now, here's another question for thought after the presentation. What does your business have to do if you determine that a worker is an employee rather than an independent contractor? So just to summarize again, if you determine that your worker is an employee, the business must withhold income, Social Security, and Medicare taxes from the person's pay. And the business must pay half the Social Security and Medicare taxes due for the employee. The business will also have to pay for workers' compensation and unemployment insurance coverage for the employee. And as mentioned in the presentation, there are other federal and state laws that apply whenever you hire an employee. For example, the business may need to pay the employee extra for overtime, provide family leave in case of pregnancy, and provide sick leave. And also larger employers must provide employees with health insurance. So as you see, there are some pretty significant consequences when a person or a worker is determined to be an employee rather than an independent contractor. Next question. What does your business have to do if you determine that a worker is an independent contractor? So we've gone through the analysis, we looked at the control, and we determined that someone is an independent contractor. We don't have the control over sufficient control over the person, so he or she's an independent contractor. Well, in that situation, your business will not need to withhold income, Social Security, and Medicare taxes from the person's pay. The business won't need to pay for workers' comp and unemployment insurance. All you'll have to do is report the amount that you pay the independent contractor to the IRS. And many times employees, because it's pretty much easier from a paperwork standpoint and for these financial considerations, some businesses want to characterize workers as independent contractors rather than employees. But as we've seen, mischaracterizing a worker can have very significant consequences and can cost a lot of money, actually. For that reason, it's very, very important to properly characterize your worker as an independent contractor or as an employee. Now, as discussed in the presentation, please feel free to reach out to us if you have any questions about the presentation, or if you would like to see if your business qualifies for free legal services. And with that, a big thank you to all of you for joining us here today, and we'll look forward to seeing you the next time. Goodbye.